Calamity in Congress, public outrage, and a potential revival. H.R. 404 is certainly going through the works this week. This is the Hearing Protection Act. Let's talk about it. Hey everybody, welcome back to the channel today. We're going to stay on the federal topic today a little bit with the Hearing Protection Act because it could have ramifications here in the state of California. I promise we will get there, but to talk us through that today, we have brought back on the CRPA President. That is Chuck Michel. Chuck, thanks for being with us today.
Thanks for having me, guys. It's always a pleasure.
Absolutely. And guys, before we get into it today, please be sure to like, share, and subscribe to these videos. It really helps get the message out there. It's going to be really important if things fall in line here with this federal legislation that could be affecting California, and that is on the Hearing Protection Act. So please be sure to like, share, and subscribe. It certainly goes a long way. So let's just jump right into this. I guess we can start with the most recent ex-post and work our way backwards with the Hearing Protection Act. If you guys are not aware, and maybe you've been taking a break from the internet for a little bit here, the Ways and Means Committee in Congress just had a committee meeting where they heard the HPA, which is the Hearing Protection Act, which is a proposition that would effectively take suppressors off of the NFA, no longer categorize them as firearms, which would essentially deregulate them. Of course, we don't have too much concern as it currently stands in California because California state law bans suppressors anyways. But like I said, I promise we're going to get there. Let's go ahead and look at the National Association of Gun Rights. Jacob, if you could pull up this X post, I think it's kind of interesting. And it reads like this: Our gun lobbyists on the Hill are reporting office phones are ringing off the hook, with patriots demanding full deregulation of suppressors and completely demolishing the NFA in each office they visit. So why the heck is this X post out there? Chuck, I'm going to ask you to jump in here in just a second. Essentially, we had a committee meeting, and in a committee that has a majority Republicans, you would expect a bill like this to pass through with flying colors. Obviously, it did not. Can you go ahead and let us know exactly what happened in that committee meeting?
Well, I think there's been several meetings, and not all public. There's been a lot of debate on the Hill about how to go about what should be done and how should it be done to get rid of not just suppressors, but also short-barreled rifles, short-barreled shotguns, and any other weapon category firearms. Get them out of the National Firearms Act, which originally was passed as a tax measure because they didn't think the Second Amendment would allow them to criminalize the possession. So they imposed a tax and a registration requirement on suppressors and the other NFA items. And so the tax currently is $200. And if you possess one of these under federal law without having registered it and paid the tax, that's a crime. So the debate was how do we get rid of this? And if those of you who are watching this probably been watching the argument about the reconciliation bill, Trump's one big beautiful bill. They have to get it through as a budget reconciliation bill in order to avoid requiring 60 votes in the Senate, which they don't have, if it's just a straight up new bill. So the argument was that you could do this as a reconciliation. You could eliminate the tax and the registration, in other words, the entire process from the NFA, and put it in the reconciliation bill. But there were others on the Hill who argued if you do that, this isn't reconciliation anymore, and you jeopardize more than just the Hearing Protection Act, because this might be a bill that has to go to Senate and get 60 votes. So the initial step was, now that's one argument. The other argument is that some of the players out there, the businesses that facilitate registering, some of the businesses out there that facilitate registering NFA products or creating a gun trust to possess those products in states where it's not illegal by state law are going to lose money if they get rid of the registration requirement. Nobody cares about the $200 tax. It's pretty well agreed that they would eliminate the tax, reduce it to zero. But that's not the problem. Really, is the registration requirement and having to go through that rigmarole to create a gun trust or whatever paperwork you have to do to possess the suppressor legally under the NFA. So that's the debate that's taking place this morning. I think the House Ways and Means Committee introduced a amendment to the Hearing Protection Act, which will eliminate the registration requirement entirely. And that's really what we want. It's baloney that these things are listed as NFA items to begin with. Suppressors are obvious. Well, for those who don't realize, I mean, they're basically hearing protection devices. They're not silencers, so to speak, like an assassin's tool, which is what the gun ban lobby would portray them as. They are hearing protection and to some extent recoil reduction devices that really, considering all the complaints that rangers get about noise and the damage to people's hearing that's done, and all the things that you have to wear, the hearing protection that you have to wear at a range in order to protect your hearing. It should be a no-brainer to allow suppressors by law-abiding citizens, and they are in common use in most states, even though they have to be registered. They're possessed widely across the country, so they should pass the Heller common use test. So that's the fight that's going on in DC, and that's changing, hour by hour back there. All the big players, NRA, NSSF, GOA, are all heavily involved in lobbying to get the NFA registration requirement and the tax eliminated.
Well, and apparently the individual citizens are as well. I gotta believe that these amendments that were proposed this morning end up being a result of the backlash that these legislators got for coming out of that initial committee meeting where all that they did was take away the $200 fee. They kept the registration intact. So a lot of good stuff there. It looks like a really good opportunity moving forward if those amendments were put back into place. So the opportunity to remove the registration components and all of that from the NFA is still intact. So good there. But why should we even care? We're in California here. State law already bans suppressors. So why would you or I care about what's going on in Congress? Well, I'll answer my own question, because there's litigation here that seeks to remove those bans on suppressors. So if we can talk about this, I've got a brief here for the Sanchez v. Bonta case. Jacob, if you could pull that up onto the screen, I want to read this really quick, and then Chuck, I'm going to ask you to explain. So guys, it reads like this. At least a part of it does. Meanwhile, the Supreme Court has repeatedly explained that the Second Amendment prohibits states from banning arms in common use. The Supreme Court has broadly defined the Second Amendment's reach to include all instruments of defense, which necessarily includes instruments like suppressors, which affect the functionality of a firearm. The district court below erred in dismissing Mr. Sanchez's complaint. California's suppressor ban is unconstitutional under the straightforward application of Brewing and Heller. Under Brewing, the first task when confronting a Second Amendment claim is to determine whether the Second Amendment's plain text covers the individual's conduct. The relevant conduct here is possessing a firearm equipped with a suppressor, and possessing a firearm equipped with a suppressor is conduct protected by the plain text of the Second Amendment, because it's a firearm equipped with a suppressor is an arm subject to the Second Amendment's protections. So, I mean, just a small piece there, but can you explain this here? You've got some in here that obviously the district court dismissed Mr. Sanchez's case originally. Can you go ahead and walk us through this lawsuit, walk us through the arguments here and where it looks like it's going?
Yeah. Unfortunately, some folks take it upon themselves to file pro per lawsuits. Now, look, it's not like we don't think suppressors should be, the California law banning suppressors should be on the books. It should be unconstitutional. But there's a time and a place. CRPA has been working with the American Suppressor Association for over a year now, getting lined up a lawsuit to challenge the California state law banning suppressors. There's litigation through the ASA in several states right now. We were kind of waiting to see how those went down before we pulled the trigger here. But an individual, Mr. Sanchez, filed his own lawsuit. Now, he lost in the district court and then took it up to the Ninth Circuit. Once he got to the Ninth Circuit took a look at what he was submitting and said, you need help. And so they kind of put out the word for lawyers to step up and represent him. And we got that call, and CRPA's law firm and lawyers stepped in. So we basically worked with another law firm that had done some work on these before and filed a brief on Mr. Sanchez's behalf. It's the party brief. It's not an amicus brief. It's the actual party brief. We now represent Mr. Sanchez, and we filed the brief arguing that the California state suppressor ban is unconstitutional. And this is what gets back to the whole shenanigans that are being played with the Brewing ruling by the Ninth Circuit Court, because they just finished declaring that magazines were not, quote unquote, arms. So they're not protected by the right to keep and bear arms if they hold over more than 10 rounds. And now the state is arguing that suppressors are not arms and so are not protected either. So that's primarily the fight. Remember, there's a two-step process with Brewing. The first is the conduct covered by the text of the Second Amendment, the right to keep and bear arms? And that's not just a particular piece of hardware. That's all the ancillary rights, right to repair, right to practice, right to hunt, right to go to the shooting range. All those things are part of the right to keep and bear arms. Then the second test, if they are covered by the plain text of the Second Amendment, is whether or not there's some historical analog law that would indicate that the founding fathers would have tolerated the modern law because they tolerated something similar back in the late 1700s. So that test has been completely bastardized by the Ninth Circuit and twisted and stood on its head and turned into something that's not. So that's what our brief points out, that the Supreme Court has told you, Ninth Circuit, what an arm is, and suppressors are covered by the Second Amendment. So then the state has to come up with some kind of a justification based on a tradition that would allow it to ban suppressors. So that's the argument that's taking place in the Sanchez case right now. But CRPA has been working with the ASA to try and get this California state law off the books for a while. There's only a few states that have suppressor bans. Most states are just covered by the NFA. And so that's why you've got this kind of a booming business for gun trusts to possess them and register them and pay the tax on them, because people realize the value of these things as hearing protection aids. I mean, imagine a range that didn't make all the noise that they make. It'd be a lot easier to operate a range, and people wouldn't be getting their hearing damaged.
Right, and I'm sort of curious. Is there like an advantage here? What's the draw to jumping in on the Sanchez case as opposed to waiting and filing later down the road?
Mr. Sanchez pulled the trigger, so we had no choice. That he had already filed his lawsuit, lost in the district court, and now was on appeal in the Ninth Circuit. And God bless him, his heart's in the right place. We all want to get rid of this stupid law, but when people try and do this, some folks who may or may not be lawyers read the Heller and the Brewing decision. They think they can staple it to their lawsuit and mail it in. It's not that simple. It's unfortunately it should be, but it's not. And so there's been several instances in the last few decades where bad law was made by people who didn't time their lawsuit right and got a bad ruling because they weren't fully prepared and didn't have all the resources and the expertise and the skill set to competently litigate the challenge that they were bringing. But look, I mean, we're happy to be representing him. It's great to be in the Ninth Circuit. And this will be another case that gets queued up if we don't prevail to the Supreme Court, along with some of the others from the other states across the country. And then if we get the NFA knocked out federally, that will open all the states that don't have state suppressor laws to possession of these very utilitarian products.
Yeah. So you hit the logical conclusion there. So it's it might seem out of place talking about something like the Hearing Protection Act in Congress when you have suppressors banned here in California, but that certainly does seem to make what's going on in Congress all the more important. If we can strike down the ban here, then what they're doing over there in Congress, it would very much affect us here, whether they do it now or later, hopefully now. And hopefully the lawsuit here can get wrapped up as quickly as possible too. So I guess let's move on to final thoughts and your opinion. Where do you see both of these things going? You've got political or not political. You've got public outrage with the way that this is kind of being handled in Congress with the Hearing Protection Act. You've got a fresh-ish lawsuit here. How do you see both of these things moving forward?
Well, I think you're asking me to predict the future, but to the extent that the political pressure on the Republicans takes hold, and I think it has, I think we're going to get rid of the NFA provision that includes suppressors and maybe even SBRs, short barreled shotguns, AOWs, the any other weapon categorization, maybe even some of that. Those are two different acts, two different proposed laws. Suppressors is the one that's getting all the attention right now. I think we'll probably get rid of that. No registration on suppressors. No tax. It's just you can go in a store and buy one. But then they'll be illegal in the states that have state laws. And California, given the overt hostility to the Second Amendment from the Ninth Circuit, it's going to depend on who the three-judge panel is. And I don't think we know that yet. Because if we get Judge Van Dyke, there's a big contingent of Ninth Circuit judges that understand the Bruin test and apply it faithfully and would strike down a lot of California's unconstitutional gun laws. But then they may try and take it en banc again and play those games. So it's really tough to say what the future of the California state law challenge is. Meantime, we're monitoring the state law challenges in other states that have suppressor laws and see where they turn out. But again, this is another topic that's queued up for Supreme Court review. What is an arm? It's more than just suppressors. I mean, the Duncan case, CRPA's Duncan case, and I give a hat tip to the NRA for partially funding the appeal on that. Is a what is an arm case, and the Supreme Court may be very well waiting for Duncan to get up there, and we'll be filing our petition for cert any day, and to put it together with Ocean State Tactical and Snopes, and then decide which one of those or which ones of those it wants to hear.
Well, and certainly the way that California has been attempting to categorize magazines in that case, it will likely play a role. I would assume it would likely play a role in any challenge to the suppressor ban here as well. Well, certainly a lot to look forward to there, and I'm sure that we're going to have you on shortly with the Ways and Means Committee having a couple more meetings. And
we are. CRPA is involved in all of this. And we are spending a lot of time and energy in trying to get this law overturned, both in the federal level and the state level. So if you can help support CRPA, we pretty much need funding to pay off the bill on the Sanchez brief and also all the other cases that we have going. We get great discounted rates, nonprofit rates from our lawyers. But it still takes time, and time from a lawyer costs money, no matter how you approach it. So help us out, and we'll do more. The more we have, the more legal ammunition that we have in terms of funding, the more we can do.
Well, absolutely, and looking very much forward to that. But I know you're a busy guy. I appreciate you coming on. Thanks for taking the time.
Always a pleasure, fellas. Thanks for having me.
Absolutely. And guys, if you like this video, you want to continue and see the content here in California, the way that we're pushing the two-way ball forward, please be sure to like, share, and subscribe to the videos. It's a great way for you to directly contribute to the litigative and legislative efforts here in the state. Thanks again, guys. We'll see you on the next one.